Hello everyone. So last in the last video I have covered Civil Procedure Code 1908 place of suing, which was like section 15. So which was about like court in which suits to be instituted. So in today's video, so I'm going to cover section 16. So with section 16 says that suits to be instituted where subject matter situate. Okay, let me read through the Bail Act definition. So I will explain this section later on. So subject to the pecuniary or other limitations prescribed by any lawsuits for the recovery of immovable property with or without rent or profits, for the partition of immovable property, for foreclosure, sale, or redemption in the case of mortgage of or charge upon immovable property, or the determination of any other right to or interest in immovable property, for compensation for wrong to immovable property, for the recovery of movable property actually under distraint or attachment, shall be instituted in the court within the local limits of whose jurisdiction the property is situate, provided that a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situate, or in the court within the local limits of whose jurisdiction the defendant actually and voluntarily resides, or carries on business, or personally works for gain. Explanation: in this section, property means property situate in India. So we have gone through the definition of the Bail Act. Let me explain you what exactly. I'll just have break down this section. So suits which are generally filed, which is a cause of action. So this is for the recovery of immovable property, partition of immovable property, when the family wants to do a partition of the immovable property, then the suits filed so comes under this section. So and any mortgage related suits for the like foreclosure, sale, or redemption in case of mortgage, or charge or determination of right or interest, so and for the compensation of wrong. So it might be anything like the victim of the like crime can file a suit. So this is comes under that, and for recovery of mobile property under distraint or attachment. So let me give you a little bit more explanation about the section 16. So this section tells you like where to file a suit when the dispute involves property, okay, mainly immovable property. So this is like a general rule where to file the suit where the property is located. So person like who is like a person who is actually at the loss, so he has to file the suit where the property is located. Okay, yeah, the suit in the court within whose jurisdiction the property is situated. So the court is the main thing, like the property falls under the jurisdiction of that court, so a person needs to file a suit in that court. Okay, and as I told you that those are the like cause of actions like recovery of immovable property or partition of immovable property, so any foreclosure, sale, or redemption, so or like any determination of any interest or right or in immovable property, so all this cause of actions will come into things. So like what is the exact meaning of that? Because if the suit involves land, house, buildings, or any immovable property, okay, then the case might be filed, okay, or must be filed where the property is located, nor where the parties live. Okay, as per the scope of this section 16, so only the case should be filed where the property is located, not at the parties live. And coming to the exception for this and the proviso, so if someone is seeking a relief only on based on defendant's personal obedience and the property is held, so or on behalf of the defendant. So what happens is like when a person wanted to file a suit, it's not for the property but only for the personal obedience. Like so either whether like so during that time what happens is like either where the property is situated or where the defendant resides, so carries on the way. So these are the two things, I mean, we need to consider while filing a suit. So one is that if it is an action related to the immovable property, so the suit needs to be filed where the property is situated. If it is anything which is related to the defendant, so the suit needs to be filed at the place where the defendant resides or carries on the business or works for the gain. Okay. So this applies only when the court can grant full relief by ordering the defendant personally to do something. Okay. So we are talking about the exception where like court is asking something to do, like defendant needs to do something. So the defendant has to suppose like defendant has to execute a deed or sign a document related to property, then so the suit needs to be filed at the place of defendant, okay, wherever he resides or wherever he does the business. So at that place the suit needs to be filed. Okay. And like the property in the last line, it says the like in the section property means property situated in India, any property which is related to or situated in India. So those kind of suits can be taken by the courts of which comes under their jurisdiction. Okay, anything, any property which is outside the India cannot be taken up by the courts. Okay. And I would like to give you an example for the better understanding. So any suit which is filed for partition. Okay, suppose if a property is in Hyderabad, okay, the case must be filed in Hyderabad court only, not at the Delhi court. Okay. And this is one example, and I would like to give another example which is like suit for damage to land. Okay, someone illegally built on your land in Delhi. Okay, so what happens is the person who's at the loss need to file a suit in Delhi. Okay, so he cannot file it somewhere else. Okay. So, and another example, like if they wanted to compel defendant to sign a document. So, if the court is asking the defendant to sign a document, then at that time, so the property is in Chennai. Okay, if the property is in Chennai, but the defendant lives in Mumbai. So, if they wanted relief, so what happens is the defendant wherever he is, like if it is in the property different property is in Chennai, or like so he lives in like Mumbai. So you may file in Mumbai or Chennai, anywhere. Yeah. So that is all about this section 16. Okay, let's move on to another section, which is section 17. Let me first read through the definition of the Bail Act, and I will explain in detail about what is section 16, 17 is all about. So, suits for immovable property. So, situate within the jurisdiction of different courts, where a suit is to obtain relief respecting or compensation for wrong to or immovable property situated within the jurisdiction of different courts. The suit may be instituted in any court within the local limits of whose jurisdiction any portion of the property is situated, provided that in respect of the value of subject matter of the suit, the entire claim is cognizable by such court. Okay, let me explain you what is the situation. I have broken down the definition into two parts. So one thing is like suit for obtaining relief or suit filed for compensation. Any suit which is filed for the compensation, or any person who wanted to obtain relief for the wrongdoing of the like defendant. So then that suit should be filed at the place of where the immovable property is situated. Okay, so at the wherever the property is situated under that jurisdiction, the suit the court jurisdiction, the suit should be filed. Okay. In case immovable property is situated in jurisdiction of different courts, and during the time the suit can be filed in either of the court. So what happens is like this, the property is falling under the two jurisdiction of courts. Okay. So during that time the section 617 applies. Okay. So this, when the same immovable property or a group of properties or involved in one suit lies in more than one court. Okay. During that time you have to check like which geographical jurisdiction it falls under, but irrespective of the geographical jurisdiction, the court like you can file the suit at any part of the property is located. Okay. So if property is involved in the suit is situated in territories, okay, covered by different courts, then you can file the suit in any one of those courts. Okay. In either of the courts. Okay. So not multiple suits. Okay. As long as a part of the property falls within its jurisdiction. So if two, there are like two courts, and one court, like half of the property falls in one court jurisdiction and half of the properties falls under the another court jurisdiction, then the then you can file the suit in one jurisdiction. Okay. One court jurisdiction, and like, and the suit can be proceeded. Okay. And but the entire value of the property of the suit, or like the value of the suit, is within the court's jurisdiction. You have to make sure that either of the court has a full value of the property covered. So because as per the pecuniary jurisdiction, okay, rules. So why this rule exists? Because see, to avoid forcing the plaintiff to file multiple suits. Okay. Just because the same land property falls under two or more court jurisdictions, it doesn't mean that, say, you can file at the both the courts. No, that is a unnecessary wastage of time. Okay. So it is an important condition where you like wherever like you file the suit must be legally allowed to try the suit of total value. So because I earlier like mentioned that the suit, like the pecuniary jurisdiction, so based on the monetary value of the courts, the court will hear the matter along with the territorial jurisdiction. So the court should have the pecuniary jurisdiction, then only the court can uh, listen to the case and finalize the matter, so between the parties. Okay. So not like they should have all the three types of jurisdiction, then only they can hear and dispose of the matter. Okay. And let me give you some examples regarding that, like single land, like there are single land parcels in two districts. Okay. So A, which is like owns a large land parcel, lies partly in district A. Okay. And partly in district B. Okay. So what happens in that time is like you can file a suit in either district A or district B court. Okay. So, and let me give another example, like whenever there are multiple properties in different places. Okay. So you file a suit claiming right to three properties, maybe like one is in Mangaluru, one is in Mysuru, and one is in Mangaluru. So you may file the suit in any of the three jurisdictions. You cannot file the suits in all the three locations. Okay. So and those courts should have the pecuniary limitation as well, so they should have the pecuniary jurisdiction as well. And so meaning of that, like provided that in respect of like the value of subject matter of the suit, the entire is cognizable by such court. Okay. So even if the property is spread across the jurisdiction of different courts, so you can file the suit in any of the courts. Okay, any of the one court. Okay, so that is what I am insisting for this section. We should be very careful while doing that. So the courts you choose must be capable of trying a suit for the full value of your claim. Okay, so it should handle the case. So it should take up the case of the full value. So it should be in a position. Okay, not just part of it. So if the total value of the suit is higher than what the court is allowed to handle, then the court cannot take the case, because that is a very like, because the other person who lost the case has the every opportunity to file an appeal and say that the court which has tried the case initially doesn't have the jurisdiction. So that like he can file, and so he can file for an appeal and get that judgment to be invalid. Okay, and let us move on to the another section, which is like a, we have heard like section 17, and let us look at the section 18, what is says. Okay, the place of institution of suit where local limits of jurisdiction of courts are uncertain. So where it is least to be uncertain within the local limits of jurisdiction of which two or more courts any immovable property is situated, and any one of those courts may, if satisfied that there is a ground for the alleged uncertainty, record a statement to that effect and thereupon proceed to entertain and dispose of any suit relating to that property, and its decree in the suit shall have the same effect as if the property were situate within the local limits of jurisdiction, provided that the suit is one with respect to which the court is competent as regards the nature and value of the suit to exercise jurisdiction. Where a statement has not been recorded under subsection 1 and an objection is taken before an appellate or revisional court that a decree or the order in a suit relating to such property was made by a court not having jurisdiction where the property is situate, the appellate or revisional court shall not allow the objection unless in its opinion there was at the time of institution of the suit no reasonable ground for uncertainty as to the court having jurisdiction with respect thereto, and there has been a consequent failure of justice. Okay, so let us see what is a breakdown of this section. So there are like two, the section is divided into two pieces. Okay, so as per the section 18, if the immovable property falls under the jurisdiction of two courts, okay, and it is uncertain. So if suppose is there a matter of related to immovable property and the immovable property falls under two jurisdictions of the court, okay, and it is uncertain, like there is an uncertain situation where nobody knows like in which court the suit should be tried. Okay, during that stage, so what happens? Okay, it shall have effect as if the entire property is, so one of the court can take up the case and shall try the case as if the entire property is situated in the jurisdiction of that court. Okay, so it should not take up the part of the property, and it should not leave the other part of the property for trying. Okay, so it should take the entire property as a whole, and so it should be treated as entire property is in their jurisdiction and shall dispose of the suit in such a way. Okay, in so that all the entire property value covers under that jurisdiction. Okay, and any objection of the about jurisdiction is raised after the decree order has passed by the court. So suppose any of the party who's lost the suit, so they cannot go and ask the appellate court saying that the court, lower court, which has tried the case and doesn't have the jurisdiction to listen to that case and dispose of the matter. So that will not happen. So when someone goes to the appeal, okay, so it should straight away refuse to take the case, because when at the time of like filing a suit, so there was no uncertain situation. If it feels, the appellate court feels that there was no uncertainty, so it was very clear that the property was under the jurisdiction of only one court, so then the appellate court can straight away say that it was invalid. But if at the time of institution of the suit, if there is an uncertain situation regarding the property, or the court where the court needs to be taken the suit, so during that time, so then it should straight away object of taking an appeal. Okay, so yeah, let us discuss more in detail about this. So like as per the subsection 1, so when jurisdiction is uncertain, okay, if it is uncertain where the property lies in court A or court B, okay, so we can file the suit in any one of those courts. the court must be satisfied that there is a genuine uncertainty. Okay, and court also must record a statement that such uncertainty exists. Okay, the court may then hear and decide the case finally. The decree will be valid as if the property was definitely within its jurisdiction. Okay, as I mentioned earlier, like it should try the case as if the entire property is situated in their jurisdiction, so it can try the matter and dispose of the case accordingly. So, and there is a condition and provision for this. So, the court you choose must have authority to try the suit. Okay, based on the nature of the case. Okay, and they should have the pecuniary jurisdiction to handle the value of the case. Okay, and coming to subsection 2, when so first, like subsection 1 was like when the statement was recorded. Okay, and subsection 2, the state when no statement was recorded. Okay, so during this, if the trial court did not record. Okay, what happens is, see, trial court did not record the uncertainty statement. Okay, if someone objects later and says that the trial court had no jurisdiction because the property was actually outside the limits, then the appellate court will not accept this objection unless both the conditions are true. So, what are those conditions? One is there was no reasonable ground for uncertainty at the time the suit was filed, and another ground, this has caused a failure of justice. Okay, so yeah, so this is like both conditions. When both conditions are true, will not accept the objection. Okay, so let us see like what is a true meaning. Like, so if there was a genuine confusion about which court the land falls under, so court can decide the case. Decree remains valid. Okay, and appellate court will not disturb it unless there was actually no confusion at all, and the mistake is choosing the court caused injustice. Okay, so I'll give you some examples so that it will be very clear. So for the example one, uncertain boundaries. Okay, a village lies on the border of district A and district B. So you don't know which district the land belongs to. Okay, then you file it in court A. Court A records uncertainty, hears and decides the case, and finally gives the decree, which will be a valid decree. Okay, so they cannot later on go and challenge it in the appellate court. Okay, so I'll give another example. So no, the court hasn't recorded any objection. Okay, so no recording, but objection raised later. Okay, suit filed in court A, like the property in A or B. Okay, likely in A or B. Okay, court A does not record the uncertainty. Okay, then the decree will be passed. Okay, and defendant appeal saying the court had no jurisdiction. So it has not recorded the uncertainty. So the court say the defendant who has lost the case, and he has appealed to the appellate court saying that the court had no jurisdiction. Appellate court checks was there a reasonable uncertainty at the filing time. So if it is yes, or like was there any failure of justice? No. So objection rejected. The decree which is given by the lower court will be standing. And like I'll give another example. Let's see, court selection causes injustice. So if at the time of filing it was clear the land was only in district A, the plaintiff filed it in district B without any confusion. Okay, then the defendant was prejudiced, failure of justice. Okay, so it is very clear in this situation. The land was falling under the jurisdiction of district A, in the district A, and the court which is under that jurisdiction can take up the matter. There is no confusion on the face of it. Okay, so it was like it is a gross injustice done to the defendant. So during that time, he'll go for filing an appeal, and appellate court may set aside the decree which is passed by the lower court. Okay, this is the scope of section 18. Okay, and let me walk you through the section 19. What it says. Okay, suits for compensation for wrongs to person or movable. where a suit is for compensation for wrong done to the person or to the immovable property if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of jurisdiction of another court. The suit may be instituted at the option of the plaintiff in either of the said courts. Okay, so the illustrations are given in the section 19. So let me walk you through that. So A, residing in Delhi beats B in Calcutta. So B may sue A either in Calcutta or in Delhi. So here what is happening is like A has beaten B in Calcutta. So he has come for some work. So there might be some provocation which has happened, or like there might be something else which might happen. So that made A angry and beat B in Calcutta. Okay, and after that he went back to his place. So B has the option. Okay, so because he was the party who has like he felt the heat from the A, so he wanted to sue. Now B wanted to sue A, so he may be having the option of suing him A in the Calcutta or in Delhi. Okay, at both the places. So and let us look at the another illustration, which is A residing in Delhi publishes in Calcutta statements defamatory. So A who resides in Delhi publishes in Calcutta so defamatory statements on B, saying that he is doing like his character assassination. So B may sue A either in Calcutta or in Delhi. So he has the option of suing the Delhi and also in Calcutta. Okay. So let us look at the explanation. What is all about? So commitment of wrong to a person or movable property in one jurisdiction. So there was a wrong which has happened to a person or a mobile property in one jurisdiction. Defendant resides or works in different jurisdiction of another court. So defendant has traveled, but he went to a place where he resides. Okay, in different jurisdiction of another court. Suit may be filed in either any jurisdiction. So the person who got hurt or like he who is a victim in this case, then he can file the suit in any jurisdiction at at the option of the plaintiff. Okay, so that will be like mm it may be Kolkata or in like Mumbai. So that is what Kolkata or in Delhi. Okay, I'm sorry for that. So yeah, so let me give you like few inputs on like what exactly it is talking about. So it tells you like section 19 is like to file a suit for compensation when the wrong is done. Okay, so a person like who was like got assaulted, defamed, or injured, or like what happens is like or a mobile property like he got stolen or like any damage was done to his goods. So this section particularly handles those kind of a situations. Okay, so the rule, what is the rule is saying, like the plaintiff can file the suit in either of the courts. Okay, when a wrong is done in one place, court's A's jurisdiction, but the defendant lives in somewhere else and he does this business somewhere else. So you can file the case at the place where the A got assaulted or like he got beaten up by B or like yeah. So then like he can sue, like he has option, like A has an option to file a suit at the place of the wrong or at the place of the defendant resides. Okay, he has option. So he can file the suit. Okay, and as I gave you the illustration, it is like very clear, like yeah. So in case of defamation or in case of like any hurt. Okay, so that time like the person who is a victim or like the plaintiff wanted to file a suit, he has the option. Okay, so at his convenience, like if he is beaten up in Delhi, then he will be suing it in Delhi because he doesn't want to go to the place of defendant. Okay, but he has the option of filing either of the places. Okay, and why this rule exists, like to avoid inconvenience